So from one English lawyer to another English lawyer. My old friend, Abhilash Nair, now at the University of Exeter, who's going to talk to us about pornography and access.
What a lovely introduction, John. Thank you. I'm going to talk porn here. Okay, so the context of this talk is essentially to give you some context about the regulation of adult pornography online. I'm not going to talk about indecent images of children or its combating strategies. This is solely focused on adult pornography. Now, it is complex at multiple levels, so what I intend to cover here in 15 minutes, if I can, is to give an overview of the regulatory history, some early legislative attempts in the US, and the impact it had on other countries, including the UK, and many liberal democracies around the world, and how we should now, or why rather, we should now move on from the old standards, obscenity-based standards of regulation, what I call content-focused regulation, to a more useful, access-focused regulation. Okay, so why is it so complex to regulate? Why is adult porn so difficult to regulate? There are multiple reasons for that. As a starting point, adult porn is lawful in many jurisdictions, and pornography per se is not illegal in those jurisdictions in particular. What is illegal is the publication and distribution of obscene articles, which is a subset of porn. But again, what is obscene? Also, it's a complex, fairly fluid concept to define. There is always tensions, especially in countries where porn is lawful. There is this inherent tension between freedom of speech on the one hand and attempts to restrict content or censor speech, because porn forms part of protected speech in many countries. In some countries where porn is completely banned, everything is fine because there is no need to regulate. Internet does not pose any particular problems. You can just block it regardless of VPN and everything else, but I don't like it. I think adults should have the right to consume lawful content, adult content. Now, a particular problem area is obviously the main focus of the discussions here is child safety and child protection, children's rights, children accessing adult content that are intended for an adult audience. There are multiple regulatory perspectives on pornography, adult pornography. There are different rationales for or justifications for regulating porn. Some use morality. Porn is bad. It depraves and corrupts people, turns good people into evil ones. There is the feminist argument that porn objectifies women, it desensitizes men, and it's degrading to women, so on and so forth. It's also worth noting there that's another school of thought within the broader feminist scholars that actually porn also has a role in empowerment of women because they make a free choice in what it does, so there's no consensus there. What I'm trying to say here is there isn't consensus on either morality-based regulation or feminist-based regulation. Same goes for civil libertarian argument. It's part of protected speech, freedom of expression, so it should be allowed. But again, you find that there are certain types, categories of content within adult pornography which transcends boundaries of what is acceptable to a right-thinking person, a reasonable person. And of course, there is a market argument. If that's what the market wants, that's what the market gets. In the UK, there has been a recent report from Ofcom which highlighted that approximately 50% of the UK's adult population have watched pornography within a certain period of time. So that speaks to how popular porn is. And I've got child protection at the end in bold because there is more of a consensus there, unlike all of the other factors I've mentioned, that adult content should not be accessible to children. There is more of an agreement internationally among people that it is inappropriate for children to consume adult pornography or to be given access to adult pornography. So there have been a few early attempts to legislate. If you were born around this time, if you were alive then, you would remember this cover story that Time magazine ran, cyber porn. essentially synonymizing the internet to a repository of porn. So porn was seen as the same as the internet. That was based on a study which was eventually discredited. So I won't rely on that very much, but nonetheless, what it led to was it resulted in a moral panic in America about regulating porn. So in the US, it's particularly difficult because of the First Amendment implications. Right to free speech is guaranteed in the Constitution, the First Amendment, and non-obscene pornography is part of protected speech. Obscenity is not protected by the First Amendment, but pornography is. So there is, of course, that inherent tension again, censorship versus the First Amendment. In the US, and as is the case with many other countries, regulation is generally focused on restricting publication and distribution of obscene materials rather than its private consumption. And the obscenity test in the US itself, I won't go over everything there, but suffice it would to say that the test is very much based on local standards, contemporary community standards measured at state level rather than at federal level. So that recognizes that what people find acceptable in one state, one society, within the same country, might be unacceptable in a different part of the same country. And in 1996, there was the first significant legislative attempt to regulate adult porn, the Communications Decency Act 1996. Idea was to prevent children from accessing indecent material on the internet, and it made it a criminal offense to engage in communication that children can reach. Now, it was criticized and it was challenged by the ACLU within 24 hours of its enactment on a number of grounds, including that the indecency standard in the legislation was unconstitutional, vague, it's not defined in statute, and it was difficult to ascertain the age of the users. And blah, blah, blah. Long story short, the court agreed, and it was held eventually that the CDA undermines substantive speech-enhancing benefits of the internet and was struck down as unconstitutional. 2 years on, the government responded with further legislation, the Child Online Protection Act, 1998. It was designed to rectify the drawbacks of the CDA, and it made it a criminal offense to propagate material online that was harmful to minors, which itself was defined for commercial purposes. So unlike the CDA, it was tailored to commercial communications only, and even that was defined in the Act. Harmful to minors was also defined, adapting from the general obscenity test found in Miller I talked about earlier. And it also provided some defenses there, of which age verification was one. Attempts made in good faith for age verification using, for example, credit card verification, identity number, or digital certificate could be a valid defense. Despite all of that, it was also challenged within 24 hours of its enactment by the ACLU as imposing an impermissible burden on speech for adults and violating First Amendment rights of minors, and also being unconstitutionally vague under the First and Fifth Amendments. It ended up in a protracted litigation that lasted 10 or 11 years, one of the most protracted litigations in US history, really, going back and forth between courts. And I want to focus on this particular slide for a second. When it went to the appeals court, the Court of Appeals for the Third Circuit, they specifically focused on the application of contemporary community standards. That's obscenity test, pretty much. And they said that in itself makes it unconstitutional, because a publisher based in the state of New York, with obviously more liberal standards than somewhere like in Tennessee, will have to then bear in mind the community standards of Tennessee when they publish something online. And that in itself is an impermissible burden on his right to free speech. So, which is quite interesting. That meant that people anywhere in the US had to be mindful of the community standards of the strictest society within the country. So for that reason, the Circuit Court said that it is unconstitutional. Supreme Court disagreed on that point, and they said, well, actually, it's your choice to publish online. So if you choose to publish online, then you have to then be mindful of the standards of the laws that apply in all parts of the country where that content can be accessed from, and that is all of America. Went back and forth, and eventually in 2009, the Supreme Court struck down the COPA 1998 as unconstitutional as well. Now, what does that mean for other countries? And the US hasn't had anything since in terms of meaningful regulation for adult pornography. And in 2022, here we are still talking about it. And the implication for the COPA CDA litigation was that adult porn has remained largely unregulated on the internet for all practical purposes since then. Nothing significant has changed, although changes are in the horizon. And the UK also had similar stories to tell. Obscenity test, again, it's similar. I won't bore you with the detail. But again, similar to the US, regulation focuses on publication of content rather than a simple possession. Now, what happens when the publisher is based abroad, which is the case in most mainstream porn sites that can be accessed in the UK? What happens? Now, strictly speaking, we have a precedent, Aaron Perrin leading case. It was held that Perrin is an interesting case, actually, because it involved a website which had a free part, a teaser pages, which was accessible to everybody, including children. And there was the premium paid subscription part for which you had to sign up and adults could access that, presumably. So the court held that the parts of the website that are accessible to all, to children, it breaches Obscene Publications Act because the content can be deemed as obscene with respect to children. This is another problem with the obscenity test, not a problem, another feature of the obscenity test. The same content can be deemed as obscene with respect to children, and it could be perfectly legitimate, lawful with respect to adults. Again, even within adults, what is obscene can also vary because it depends at the end of the day on the interpretation of the people judging content for obscenity or not, whether it has a tendency to deprave and corrupt people who come across such content. So, applying Aaron Perrin, in theory, any website that streams content into the UK without any access restrictions, access controls, are technically in breach of the Obscene Publications Act. Now, we all know that. Do we do anything about it? No, because it is one thing to have substantive laws in place, but whether it can enforce it, they can prosecute, is an entirely different matter. So we have laws, but we don't. That's where we are. So what I'm trying to say here is transposing traditional laws to cyberspace based on the obscenity standard has failed. You cannot rely on those notions of obscene, morality, and other things and apply that to the cyberspace environment. Because at a basic level, an obscenity standard requires identifying a community, a local community. How do you do that on the internet? You couldn't find consensus in one country, let alone internationally, so that is not going to work. So the argument being, traditional content-focused laws need to make way to access-focused regulation. And the rationale, the sole legitimizing factor for that should be restricting children's access to online porn. No more or no less. Now, I'm going to end this with a bit of a theory. Law for to succeed in cyberspace needs to be meaningful and respect-worthy. That has two elements. Laws that do not command the respect of those who are subject to them are likely to fail. Laws that cannot be enforced are also likely to fail. And older models of regulating porn, unfortunately, has both those deficiencies. Like I said, standards of obscenity are quite fluid, subjective, subject to interpretation, doesn't work. Laws that cannot be enforced, doomed to fail, are Perrin. The other example, whereas child protection or restricting children's access as the legitimate basis has the potential to offer the basis for regulation. That's why it's so important that we should focus purely on access-focused regulation rather than content. And that I summarized from a chapter from my book, which I'm using the opportunity to promote, really, but it involved a lot of research, too, in that chapter, which I summarized in 10 minutes. So, thank you.
Thanks very much. Abhilash will be around for the rest of the day and this evening. By the way, his book is only £125.
Oh, it's
Okay.
£29.99
Oh, no,
now.
they've got a
It's
paperback version out now. That's academic publishing for